rarely achieved when you're at exactly 2:15. Yes.
Thank you. Just before my lady and your lordships came back into court, we were just trying to get the text of paragraph 276 AD.
Well, the link we were sent was to the whole of the rules, and so it's there as well.
It is in there. I haven't managed to locate the page number yet. I apologise.
Oh, I see. Well, don't worry. We can find it. I just, especially as a point is taken on the wording, I think we just need to have the authorised version. If we've got it somewhere, that's good enough.
Yes, I haven't had a chance to check it. I don't know if I'm speaking ahead of my learned friend. She may make the submission that that paragraph was not in force at the time of the appeal hearing, and it would still be my position that it was in force at that time.
Well, all right, we better deal with that in reply. But I mean, this is quite fundamental stuff. We need. Why weren't we given the rules in the form in which they were available at the hearing? I mean, it's basic stuff for the authorities.
Yes, I apologize.
You may think we all know about immigration law, we all know a bit, but for precisely this reason, you need each case to be clear what the rules were at the particular time. Anyway, let's cross that bridge when we come to it. You were going to come to your article. Can I just ask one point before we come back to your Article 8 point? Just on the point you started with, the judge summarises your submissions or at the start of the judgment, and the third one is said to be sorry, it's page 60 of the bundle, paragraph 5 of his judgment. Ms. Warren said the key issues were 1, PSG, 2, convention points, Article 8 and Article 3, and then 3, that it was necessary to consider whether the appellant was entitled to humanitarian protection.
Yes.
Isn't that inconsistent with the more extreme version of your submission this morning?
No, for the reasons that I said in relation to the skeleton argument. It was our position that had been found and that was not unchallenged.
Why did you say it was an issue?
To confirm that point. To make that submission, which is contained at paragraph 15 of my skeleton
very
argument.
well, okay. I just thought we hadn't looked at that passage, but you said the same answer.
Yes.
Very well. Now, Article 8, or more accurately, paragraph 276 ADE. So you're not making any point about Article 8 outside the terms of paragraph 276.
Sorry, go back a step. You wanted to make the submission, you said at paragraph 15. Do you mean the one at paragraph 20, the one about, is it paragraph 20? International humanitarian.
I think you mean paragraph 15 of your skeleton.
Of my skeleton.
Your skeleton, yes. Not the judgment. Because you say the judge muffed it. It's paragraph 34. Yeah. So you say the judge got it all wrong at paragraph 34 because he just didn't deal with it. Is that? I'm on the right point?
Yes, the judge of the first tier dealt with it at paragraph 28.
Yes.
And I referred to that at paragraph 15 of my skeleton.
Yeah, and then we get to paragraph 34 of what the judge says, which you say is an inadequate.
Yes, dealing with that question.
I'm there. Thank you very much.
Yes, dealing with my last ground.
Yes.
Which deals with Article 8. I want to explicitly...
Okay, again, just so we're clear about this, it is the Secretary of State's position that Article 8 is covered, subject to one or two very exceptional cases, is covered by the rules. And the Article 8, insofar as it refers to private life, is covered by paragraph 276 ADE. So that's where we ought to be focusing, isn't it?
Yes. And I've laid out the test under which we say is the material part of 276 ADE.
In your skeleton?
Yes, my skeleton for this court at paragraph 74 on page 19 of the core bundle.
Yes.
So someone who's lived in the UK for less than 20 years, but is over 18 years of age, whether there would be very significant obstacles to the appellant's integration into the country to which he'd have to go if required to leave the United Kingdom.
So that's the test to be applied.
That's the test. Yes, under ADE, the rest of ADE deals with 276 ADE deals with circumstances which wouldn't apply in this court.
Yeah.
If one looks at my skeleton argument for the upper tier, at page 13 of the supplementary bundle,
Yes.
you'll see it's entitled Article 8 and Best Interests.
Yes.
And best interests is dealt with essentially as part of those very significant obstacles. But apart that,
Sorry, I didn't hear what you said.
part of those very significant obstacles to integration should be examined as part of that test. But it's highlighted as a point that has to be examined.
Yes, it was rather the children. The children aren't parties, are they? But you say they feed in effectively to.
They're not parties, but of course.
Part of the significant obstacles would be that she'd be travelling with her children, and even if she could integrate, they couldn't. Or
their Article 8 rights are engaged by the appeal, because of course it would determine.
yes, but I'm just trying to see how it fits in.
Yes.
It fits in under significant obstacles. Is the any problems related to the children?
Yes, yeah. And the judge makes an error. I don't think it's an argument between the parties that insurmountable obstacles is an imported.
But what? Sorry.
Insurmountable obstacles.
Yes, I see.
Is an imported error.
Well, that comes from somewhere, doesn't it?
It does.
As
It
you
does
say,
come
in a
from
vague
somewhere.
way.
It doesn't come from that part of.
No, is it somewhere else in the rules?
It is, yes.
Where does it come from, out of curiosity?
It's Appendix FM LTRD EX.2. It's the. It's
Remind me which bit of Appendix FM that is.
A partner who's in the. It's a partner who's in the UK without immigration leave, which is a requirement unless he can show there are insurmountable obstacles to family life
Yes, I
continuing
see.
outside the UK.
Yes.
The insurmountable obstacles is Appendix FM paragraph EX2, and the very significant obstacles is 276 ADE, and it's also part of one of the deportation tests as well.
But Ms. Warren,
Mm.
if we look at paragraph 12 of the judgment, where as part of his extensive summary of your submissions, the judge refers to 276 ADE and says the test is still whether there are very significant obstacles. I mean, isn't it fairly clear that this is just a misspeaking when it comes back on the second occasion? And if it wasn't, why didn't you draw it to his attention?
I wouldn't have known then that he was going to put that test in.
I understand, but you get a judgment.
Yes.
You're perfectly entitled to communicate with the court and say there appears to be a discrepancy
I
between
see,
your
yes.
direction to yourself at paragraph 12,
Yes.
but otherwise it rather looks like a slip of the tongue, doesn't it?
I wouldn't say it's a slip of the tongue because it is repeated within his determination.
I mean, it's very significant obstacles is referred to several times in the judgment when you're making your submissions correctly. But I mean, are you expecting us to conclude that the judge referred without comment to the correct test, but then went on to apply an incorrect test?
It appears he recounted my submissions
Yes.
on that point, but when he held the test in his own mind, it appears to have held the wrong test in mind. I mean,
Yeah,
on the
okay.
face of the judgment. That's
Yeah,
what
you
it
say
is.
that's what he said in the bit in the dispositive bit, and therefore we must assume that's what he was applying, right?
Yes.
Okay.
Yes, it's what he asked, or he asked himself at the beginning of paragraph 52. There appear to be no insurmountable obstacles to family life.
Yeah, but no, we've seen. Yeah.
I want to explicitly resolve from a point that I make at paragraphs 77. Sorry. I'm looking to write on the slides and that's what I did.
Well, paragraph 77, you go on to make a completely different point about not taking a balance sheet approach.
Yes, that's the part that I wish to resolve from.
No, that's fine. So
I don't think that's an error of law,
no,
but I do think the error of law remains, if I could put it like that. I don't think it's an error of law not to follow a balance sheet approach. It is recommended for clear reasons, but it is not an error of law if the judge completes a lawful assessment apart from.
that's if I may say so, a sensible concession.
But you still say he got it wrong, don't you?
I still say he got it wrong. I think the quote from Lord Thomas in Hench and Alley draws a distinction in his paragraph 82 to 83 between what is required and then the balance sheet approach. He says judges should, after making their factual determination, set out in clear and succinct terms their reasoning for the conclusion arrived at through balancing the necessary considerations. And he then goes on one way of structuring that is the balance sheet approach. So there still has to be the balancing of necessary considerations. That still
He didn't
has
do
to
the
take
substantive
place.
exercise, irrespective of whether he did it in a balance sheet form.
Yes, exactly.
Okay, we have the point.
Yes. Most serious of those in my submission is a failure to identify the best interests of the children. Of course, they are not the paramount consideration, but they are a paramount consideration.
They're a primary consideration.
Yes, sorry, a primary consideration. He doesn't seek to identify those at all within his determination.
But where in your submissions below, in your skeleton below,
Yes.
there isn't really a developed submission as to why it would be contrary to the best interests of the children. Is that fair? I'm looking at 37 to 39, that's what the judge was dealing with. You say in relation to Article 8, the statute you to best, the need is to consider. You just say all the things that have to be considered, but you don't say why they would pose very significant obstacles in the present case. Now, maybe you say somewhere else. I just wanted to.
Well, I'm looking back as he lays out my submissions because they're not laid out in depth in the skeleton argument.
So right. So the answer is that we couldn't primarily look at your skeleton argument for what was in front of him, but for his summary of your submissions at para 12.
Yes.
Yep. Okay. Thank you.
Where they are laid out in more depth there. Well, it would be my submissions that if you take, or what can be seen in paragraph 12, do amount to the criticisms of his decision as laid out in my ground 6.
Yeah.
So they were points that were in front of the tribunal.
So sorry, I distracted you. You were saying that the main thing was the most serious failing was the failure to identify where the best interests of the children lay.
Yes, and at paragraph 85, page 21.
Yeah, we've seen that. We've
I
seen
say
what it says.
it's especially important in the circumstances of this family, identifying a number of those matters, not least of which is how the appellant will earn a living, which relates to both supporting herself and her children, also relates to her procurement of...
Yes, what was the evidence about that?
Well, page 300, there is a section of the supplementary bundle. There's a section in the expert report.
Well, okay, but forget the experts report for a moment. What did the appellant herself say about what work she could do, how she could maintain herself, or any? The first place you would look for why there are very significant obstacles to me going back to my home country is in the witness, the claimant's own witness statement, and I just wasn't sure where she dealt with it. Well, to be absolutely frank, I wasn't sure that she dealt with it, but I wanted to be sure that I...
Well, I think I'm right in suggesting that this is perhaps the most distressing point to the appellant, which is contained at
So, sorry, say it again?
paragraph 133 of her
Paragraph
witness statement.
133. Give me a moment.
Page 218. And that is the fear that she wouldn't be able to afford medical treatment for her youngest son.
But is that a relevant Article 8 consideration?
I think that would come squarely into...
But I thought isn't GS India evidence to the contrary?
Well, no, that's Article 3. Article 8, of course, talks
No,
about...
Article 3. Article 3. Oh, there's a whole chunk about Article 8 in GS India. I happen to know because I wrote the judgment. What we said in
Yes.
GS India, I'm not sure it's in the bundle, but supporting or following an earlier decision, I think called said something Zimbabwe, was that inadequacies of medical treatment didn't engage Article 8.
This isn't about treatment being inadequate. It's largely about affordability of medical treatment.
Well,
her
okay, but
ability.
it's the same point. Inaccessibility, the fact that the health service is not as good in the country to which you're going back is not an admissible consideration under Article 8. That's what we said, I thought.
It's more about being able to support herself and her children, so that would encompass all parts of their private
Precisely.
life.
Okay, that's fine.
Home
That I get.
Yes, being
But
able to...
where does she say I wouldn't be able to afford, I wouldn't be able to get a job, or the judge clearly thought she would.
The difficulty is that in these pages, I mean, there are some very strong statements,
Yes.
and I don't mean to minimise the feeling that lies behind them, but there's very little information for the court to grapple with.
I think largely this question of external support can only be provided by application of the appellant's personal circumstances to background, objective and expert evidence. Of course, when the appellant was last in Albania, she wasn't self-supporting herself there, and she was still within her marriage at that point. So she doesn't have that experience, personal experience, that she can speak from within her witness statement of what it would be like if she were to go back. The expert, whose expertise has not been challenged, is able to draw upon her own expertise and the
Let's see
background
what the
evidence,
expert says.
and give evidence about that matter.
What are the passages that you rely on in the expert evidence?
In terms of explicitly about employment and childcare, because I think that was where the initial point was raised, and Judge Hanchbury does mention this. That's at page 300. Which points out that childcare is mainly done by family members. And without childcare, of course, the question is, how will she be able to work to support herself and her children? That, however, is part of a broader section within the expert report, which starts at page 291 and encompasses access to basic services. And the expert comments there upon the fact that there's limited social housing.
So, which page did you say?
That page 292.
292.
Yes. It deals with social housing. So in principle, she would be eligible for it. But this very much depends on availability, which is severely limited and oversubscribed. And she says, to benefit, the last paragraph on that page, to benefit from this programme requires an application, after which one is put on a waiting list, subject to meeting eligibility criteria. And then page 294 deals with state assistance. And at the bottom paragraph of 295, she says, should EL and her children receive state assistance, it would be able to afford them just about a loaf of bread a day. And goes on, this is the lowest cash assistance in Europe and very far from reflecting real needs or price levels in the country. And then she goes on to consider the possibility of employment at page 298 and notes consistently high unemployment rates. And the appellant is somebody who's worked as a cleaner in Italy but didn't work in Albania as a married woman. And then, of course, we get to the childcare points.
Judge, yes, I see.
And then I think the last relevant point here would be page 303, which deals with reintegration. So in addition to the question of risk and having to avoid risk from those who previously harmed her, returning as a single parent with 3 children and no family support in Albania presents a very difficult position of her being able to support herself and her children.
Can you just remind me what age the children are?
Now,
I suppose, I don't know what the right date for me to ask
10,
that
8,
question
10, 8 and
is
4.
At the time of the upper tribunal.
oh,
10, 8 and 4.
yeah.
They'll be at school. Okay.
Well, that's answered in the expert report, who says, just to find that page for you, there's far shorter. She says at the bottom of page 300, classes in the state-provided primary schools, years 1 to 4, are from 8:30 to 11, hence much shorter than the UK school. So we still need to find a solution for childcare after. I think this all has to be seen in the context of which women tend not to work after marriage. That's what makes that point through it. They're still very much at home normally, so you're in an unusual situation anyway if you're both having to support the household and do the childcare. So.
The judge says at 51,
Yes.
he has family members in Albania, including her mother. He's educated, just we know she got a degree in law.
She hasn't got a degree, just to be clear.
Done a law course.
Yes, she wasn't able to finish it after she married. So.
Yeah, I assume that's what he was referring to anyway. Well-travelled, multilingual adult in her 30s in good health. Find there to be no reason why she shouldn't find employment in Albania. So it's subject to the caveats above, house herself. Do we know what the caveats above was that he was referring to?
Paragraph 15 refers to the expert evidence on housing.
I'm not sure. Just to take issue with at least one of the parts of that paragraph, and his description of her good health, or relatively good health, doesn't seem to have taken into consideration the evidence that was in front of him about her mental health difficulties and how that might impact her ability to find employment and to.
What was the evidence about her mental ill health?
It's in the supplementary bundle. Some of it was earlier on because they were quite.
We're short of time. Just give us the reference.
16 to 17.
So supplementary bundle pages 16 to 17.
Yes. Although there's other evidence.
Well, yes, but this was evidence about her concern based on having to look after a son who at that point was undergoing treatment for cancer. They forget at what point he stabilised. But is that what you're referring to?
Yes, if one looks at the earlier evidence.
Yeah, well, give us the references.
230.
I think what we may have to do is give us the reference. We'll have to read it later because I'm anxious that Ms Jones has proper time to respond.
Yes, also then I'd refer you to pages 315, which are from her GP and reference earlier.
Again, without meaning to minimise it, these are very common conditions in the population as a whole. When the judge referred to relatively good health.
Yes, he does refer to relatively good health, but then makes no evaluation of those conditions.
But these are not likely to be conditions that are going to sound heavily in any Article 8 consideration.
I think that the point is, how do they impact upon her as a single parent if she were to return to Albania? That's the point that I make in the last paragraph of my skeleton argument with reference to the case of RA, and that's at page 263 of the authorities bundle, where it's about it's a need to consider how her mental health will impact upon her if she is returned to a situation where she has previously been at risk and feels she'll still be at risk from those who reside in the same area on the judge's reasoning.
But we only get to Article 8 if the judge finds that there is no real risk. Can we take into account a risk that isn't a real risk, simply on the basis that she's worried about it?
Well, I think we can take into account what has happened to her in the past, whether the judge found that to be well-founded or not, or whatever you
No,
make
he
of
has found
those
it to be
arguments.
well-founded.
Yeah, so those events in the past have still occurred.
Well, those events in the past
Have
course.
still occurred.
Yes,
So,
excellent.
yeah,
Okay.
thank you. Well, that completes my submissions.
Thank you very much, Ms. Warren. Yes, Ms. Jones.
Thank you. I'm aware of a need to crack on, and I'll try
Yes,
to
I
do
mean, I'm
so
sorry
as-
it's all taken a bit longer. On the other hand, the person answering has a much more, can normally be a great deal more focused. So I don't
I'll
think you
attempt-
should be in any difficulties.
I'll attempt to do so. I obtained over the lunchtime adjournment. I'm afraid I've only got 2 copies because I had one for my learned friend as well, of the relevant parts of the immigration rules under Part 11 relating to asylum on the one hand and humanitarian protection on the
Well,
other.
we were sent those over. I mean, I think it wasn't so much we had any doubt about what they said. We just wanted to have them in front of us for the purpose of writing a judgment.
Yes, and your lordships have the email I sent to your ladyship's clerk has the whole of the archive document.
Yes, Andy had the references.
It's difficult.
And then that was at the relevant date, was it?
Yes.
Was being
They came into force on the 5th of October.
what I really meant is
2023.
I'm sure you got that right. I just want to know what date you say this should be being judged at. The date of the upper tribunal's decision.
In order to determine whether the upper tribunal made a material
At
error
the
of law,
remaking,
because
okay.
it was a remaking, not
Yeah.
not a.
So the
an
relevant
error.
rules are the date of the remaking. Yeah.
Yes,
that
the
sounds
date of the remaking was 11th of October. Those rules were from the 5th to the 31st of October.
Well done.
The Secretary of State considers that the grounds in this case fall into 3 categories. There's ground 1 relating to whether it's a relevant category within the Refugee Convention. I'm going to leave that to the end if necessary. I can not make extensive submissions on that. I've referred to it in the skeleton argument as well.
Okay.
It does seem to me that although there are academic differences between the 2 forms of leave, the practical differences are very limited. The second group, which is the 2nd to 5th grounds, relate to whether there is a well-founded fear of persecution or risk of serious harm on return, and can be dealt with probably together to some extent. And the last is Article 8.
Thank you.
The second ground, whether humanitarian protection was effectively wrongly reconsidered by the judge, is slightly different to the other 2, and I will consider that first. In my submission, it's entirely apparent that the judge always intended that that should be reconsidered, that that's clear from the error of law decision which he made, and clear from his decision that he was intending to remake it, but that also it's apparent from the appellant's position before the upper tribunal that she was expecting it to be remade. If I can ask your lordships to turn first to the error of law hearing before the same judge on the 15th of August 2023, that's Core Bundle 76. The judge considered under discussion that there were inadequate considerations of matters such as sufficiency of protection and internal relocation, paragraphs 16 to 18. And in paragraph 20, the judge said the judge made a material error of law. Her decision is set aside. Her fact findings remain. So there's a clear and obvious distinction there. He kept the findings of fact, although he said there could be some further fact finding if further evidence was produced, but the decision was set aside and would be remade. And when the matter came back before him in the decision under appeal, that's page 61, he clearly treated that as the factual findings being preserved only.
When you say fact find, you mean findings of primary fact?
Yes, the findings of, and they relate to credibility entirely as to whether what she had said to the First Tier Tribunal judge was true. And the judge went on to remake the decision as he said he would, because he'd already set the decision aside. And in my submission, it's clear that paragraph 28 was included in the decision which was set aside. But further in my submission, he always understood that he was remaking that. And it's clear that he understood that the appellant was expecting him to do that. In paragraph 5, he says that Miss Warren said the key issues were, and the third is, it was necessary to consider whether the appellant was entitled to humanitarian protection. There are then the submissions made by my learned friend over paragraphs 6 to 11 in relation to particular social group, sufficiency of protection and risk. And in paragraph 20, the judge, I was urged to allow the appeal on the grounds that she qualified for international humanitarian protection if she was not a member of a particular social group. When he was considering the matters before him over a number of pages, he said in paragraph 30 it was not the task of the appellate tribunal to try and second guess the findings which had been made on the witness evidence. That's paragraph 30. And in paragraph 31, there was no reason to depart from the fact findings, but her assessment as to the nature of the threat that the appellant faces. So he is distinguishing between those two, as he has done consistently. And he then does go on to assess.
It's not ideally worded, is it? If you're right, what he meant by the nature of the threat, what he meant was there a threat?
Yes, the nature of the threat she faces and the extent and so forth. Yes,
Where does it say?
Is that the nature of the threat the appellant faces, the extent to which she
So where are you reading from?
Paragraph 31, paragraph second sentence, your lordships, third sentence, the nature of the threat. And goes on to consider those.
As I'm afraid happens many times in this, there's lots of typos or things where the sentences don't work. I see no reason to demand from the judge's fact findings either and but. I think that must mean I see no reason to depart from the judge's fact findings, but her assessment as to the nature of the threat. So we can cross out either and.
Yes.
So
because it finishes all need to be considered.
Yes, quite. Her assessment as to the nature of the threat that the appellant faces isn't terribly apt. It's more as to whether she accepts a threat, whether she faces a threat.
Yes, I think that.
Yes,
that's
and
fair.
the next title, sub 3, is not grammatical either.
No, what is the nature of the threat in Albania?
But it's probably good enough from your point of view in showing that these were live issues.
Yes.
However they are expressed or misexpressed.
Yes, it could I suppose be what is the nature of the threat or where does the threat come from. But in either event, I'd suggest it is clear that the judge has always thought, both at the era of law hearing, that he was going to remake the decision on humanitarian protection, as well as he was going to make the decision on particular social groups.
Yes, of course, not on the most extreme version of Ms. Warren's submissions, but on the more modest version. She says, yes, he still had to decide humanitarian protection, but only on the basis there was a threat, and the question was whether it could be sufficiently mitigated by internal relocation or sufficient state protection. So he wasn't looking at the whole question of humanitarian protection, but only at those two sub-questions. What do you say about that?
That is not an argument I had fully appreciated from my learned friend's skeleton argument, but I
No,
have had
that's
the
fair enough,
opportunity to consider it, and that does seem to me something of an artificial division of the issues. A refugee is a person with a well-founded fear of persecution, and in order to work out whether somebody has a well-founded fear, you look at risk and sufficiency of protection and internal relocation. To work out if someone faces a serious risk under Article 3, you need to look not only at whatever risk might arise, but again, whether they can be protected from it. The Prime Minister undoubtedly has a large number of people wishing him very significant harm all the time, but you wouldn't say he's at serious risk every day because he's protected against those threats, and you can't analyse is there a risk entirely separately from the protections against that risk. And I was going to come to that briefly because the relevant paragraph of the immigration rules on humanitarian protection specifically invites protection to be considered when you're assessing whether there's a serious risk. I beg your pardon, I'm just turning to the...
Yeah, I remember. It's in 339C. It's part of 339C.
It's part of 339C, yes. So if I could just ask
339C,
you
little
briefly-
Roman 3. Who
Yes.
face a risk of suffering serious harm and is unwilling to avail themselves of the protection of that country.
So it's all part of, you'd say,
All
animals
part of the same
part of the
package.
same whole,
Yes, and you can't...
can't split
Yeah.
out bits.
No.
So does that mean there's a hard-edged question for us about paragraph 28 of the FTT's judgment, whether that was set aside?
Yes, and in my submission, it clearly was. We're not even saying the second judge, the remaking judge, misunderstood the error of law judge because it's the same judge. So he appears clear that he had intended to set it aside and went on to treat it as him having set it aside. And in my submission it did, because he said, I'm keeping the findings of fact and setting aside the decision. And paragraph 28 is a decision rather than a fact. So I'd suggest really that the implication that the remaking was only in relation to social group or not social group doesn't reflect what happened in that hearing and all the discussions about sufficiency of protection and so forth. And it doesn't really reflect why anyone was bothering about Article 8, because if she already had humanitarian protection, then Article 8 is a less secure and valuable and useful form of leave anyway. So in my submission, it is apparent that this was always about whether there was a real risk of persecution and a serious risk of harm. And briefly, if I may, that the skeleton for the appellant does reinforce that those were the issues, because set out in the issues, supplementary bundle, page 5, the following issues remain to be decided: whether the appellant would face a real risk of persecution / serious harm.
Yeah, well, as you know, we put that to Ms. Warren, and she said yes, but he raises the question only to answer it in paragraph 15. I think I
Yes, but if you're saying that this remains to be decided, then it does
yeah, I
remain
take
to
the
be
point.
decided.
Though in fact, there are 5 points there, and she only deals with 4. If you look through, particular social group, which is 1, is dealt with. The title, the heading is at the bottom of the page.
And it
5, sufficient. Then it goes straight to 3, sufficiency of protection at bottom of page 8, and then relocation, bottom of page 10. I'm going by the bundle numbers, and Article 8 on page 13. But there we are. I just thought it isn't. Although she identifies issue 2, there are no submissions about it.
That is the case, and but of course I would say that with the greatest respect to any advocates before any tribunal, what an appellant thinks is already proved and she doesn't have to prove further isn't necessarily what she does have to prove and needs to be
But
proved
perhaps-
further. And the judge has been clear throughout
Yeah,
that it's
and
going
perhaps
to be.
fortunately, but the point you're going to come to, whatever she thought, the judge did make findings about it.
Yes.
Okay.
So those are my submissions in relation to had humanitarian protection survived the error of law and remaking decision. Those are my submissions in relation to
Thank
that
you.
ground. Grounds 3 to 5 largely fall to be dealt with together, partly because the appellant has to succeed on all 3 in order to succeed on the appeal, because she has to show first that there is a risk on return, and that there's no sufficiency of protection, and that even if there's no sufficiency of
Yes, quite.
protection, internal relocation. So it doesn't assist her if she establishes the judge has made an error of law in 1 or even 2 of those. She has to show that the judge has erred in law on all 3, because she wouldn't be a refugee otherwise. And the Secretary of State's submission on this, and for all the reasons I've already set out in my skeleton, is relatively robust, that there is no error of law. There's a disagreement about what the judge could have found, whether there was evidence which would have entitled him to come to a different conclusion, even perhaps that the judge in some respects was wrong. But none of the submissions to this court, I suggest, identify any legal errors. There's a hint occasionally there's an inadequacy of reasoning, or that it's not a perversity appeal, but essentially in my submission this is a disagreement. He could have decided differently, and most of the appellant's argument is setting out the evidence that the judge could have relied upon to come to a different conclusion, but that does not amount
I
to
see
an error.
that. Certainly, you're right, though. I think one strand in Ms. Warren's submissions is inadequacy of reasons.
Yes.
And what she says is unquestionably leave aside the threat from her family, talk about the threat from her husband's creditors. The judge really simply said twice, but without any unsupporting reasoning, that was all a long time ago, and there haven't been any threats for 6 years, and it's hard to believe there's going to be any risk now. And she says that's certainly superficial reasoning and doesn't take account of the seriousness of the injuries she suffered in the past, which he doesn't spell out, and the evidence of the expert that debt issues are never forgotten in Albania.
Yes. If I can address first the past persecution
Sorry, yes, I didn't-
leading to
yes.
further future risk, I accept that. My paragraph 46, that past persecution is an important indicator, although that case law has in effect been codified into the immigration rules paragraph 339K, which
Oh, right.
so
That I'm afraid I didn't print out. What does it say?
I think it's in that printout that
Yes, but I didn't. Which printout?
I
are you talking about?
just I
Oh,
think,
this one. Sorry, I didn't realise it had been printed. I'm so sorry. That's wonderful. 339K.
it's page 241.
Yes.
The fact that a person has already been subject to persecution.
Yeah.
So it's, although I agree that those cases are relevant, your lordships don't need to refer to them because it has in effect been codified into the immigration rules. However, that isn't a rule or a requirement, but it's a strong hint. If there is past persecution, you've got to look at it quite carefully. And of course, I would accept that there's no doubt that the treatment she suffered was serious enough to meet the persecutory threshold. And there isn't any discussion of that, but that's because it's obvious. That sort of violence would always meet a persecutory threshold. So the judge is starting from the position that he accepts she suffered that harm in the past. And he's considering whether it represents a real risk or a well-founded fear in the future. And in my submission, he does deal with that perfectly adequately in that he considers quite how long it is and what the effect is and whether anybody is really likely to care to quite the extent that it would still be a persecutory level risk. And he has considered that, having referred in paragraphs, for example, 19 and 20 to that past rape and abuse, and having referred to the expert evidence on several occasions as before him. He then, at paragraph 32, says that unless the disgruntled customers bore so severe a grudge that they are unable to forget it, it is unlikely that there's still a further risk of reprisals, and then goes on to consider that further in paragraph 35, since 2018, nothing since the incidents which were detailed, a feud as to require such self-separation from society isn't the same as a disagreement or even a debt. And he notes what the expert has said about it, but says an inability to deal with blood feuds isn't quite the same as anger over debts. And he says a more objective, nuanced picture arises from the CPIN, and he refers to certain paragraphs of it and says this isn't quite elevated to the blood feud level in paragraph 36. So in my submission, he really has set out there the basis of his decision, the material he's relied upon, and the matters arising. The expert report is said to be relied upon, including the reference to debts being serious. However, it is notable that much of the discussion in the expert report about debts being serious does say they amount to almost blood feud type or can do levels of intensity, but that was not relied upon by the appellant. It didn't amount to canon as it's called, and the blood feuds. But blood feuds having been disavowed, the judge was entitled to say the CPIN's a bit more nuanced about this. It's not quite blood feud intensity, and to make that judgment. It would be wrong to characterise the judge as just saying it's 6 years ago, nobody cares anymore. It really is a little bit more detailed than that. And in my submission, there is no error of law in the approach that he has taken. The other reasons as set out by the appellant as to the inadequacy of the risk under ground 3 are, in my submission, fairly clearly disagreements. He could have found that they might still be after her, and it's not matters which really can be held not to be legal errors. The reasons given, including the expert evidence I've dealt with so far. The third is the slightly different category of potential risk, that is risk from the husband and his family.
Not just slightly different, completely different. Yeah.
The legal position is also rather different in that although the child had been born and the expert report produced by the time of the First Tier Tribunal, it doesn't make much of an appearance in the first determination. It came far more to the fore in the remaking decision.
Does that matter?
No, but it explains why there's very little in the way of credibility findings from the first tier judgment, which were preserved because the first tier judge wasn't really considering it. So the judge was looking at that to some extent afresh, as
First
almost
time,
as a
yes.
primary decision maker. It wasn't considered by the Secretary of State because the baby hadn't been born at the time of the interview. It wasn't considered much by the First Tier Tribunal judge.
The
So
appellant had the opportunity to put in further evidence, didn't she? But
she
didn't.
had, and she chose not to.
Yes.
And it is raised in her witness statement, which is dated before the First Tier Tribunal, but for whatever reason it didn't feature significantly in the First Tier determination. But there really isn't any evidence, apart from the appellant's assertion, that her family, her ex-husband, her mother-in-law has any interest in her or the new baby or anything of the sort. The only preserved finding from the first tier is that there was an argument with her mother-in-law by phone, I think in 2019. I beg your pardon, I'm just finding the
Well, we were
record.
shown that in the witness statement. I didn't. Well, there was a finding about it as well, was there?
There was a finding,
Yes, I see.
and it was that the mother-in-law was unsupportive.
I think it's the bottom of
Paragraph
paragraph
81.
25.
Right.
Thank you. Yes, it is. And so that's the only finding which was preserved on that point. But other than that, there's very little. And although those had been preserved, the appellant chose not to provide new evidence or put anything else forward. And there really isn't anything to say that the family is interested in her at all under the risk category. Moving to the sufficiency of protection, it's accepted by the appellant that the default position for women who've been a victim of sex trafficking, and they are a social group, women who've been a victim of sex trafficking, the default position under TD is that there is a sufficiency of protection for such women. But that there might be, and my learned friend's already taken you to this part of the case, there will be some cases where, because of their individual characteristics, nevertheless there isn't a sufficiency of protection for a particular woman, for a particular risk. So the criticism of the judge here that he didn't go through all the reasons why she wasn't in the standard category is, in my submission, a little unfair, because what would have to be shown and demonstrated on the lower standard by the appellant is that she was in the exceptional category. She wasn't in the standard Horvath compliant sufficiency of protection category. She was somehow outside that standard sufficiency of protection. And in my submission, the determination from Upper Tribunal Judge Hanby does need to be seen in the light of the fact that for women who've been the victims of sex trafficking, there is generally a sufficiency of protection.
Is that carryable over to her case not being a victim of sex trafficking? Is
Well,
her case truly analogous?
If anything, it's less serious
Yes, I see.
rather than more serious, because women who have been trafficked as victims of prostitution are a social group and are a much more recognisable category much more easily, and have often been victims of organised crime as well. Not all
Right.
of them, but some of them.
Quite.
So there's nothing to show that a woman in her position is in more danger than women who've been trafficked for
I
sexual
suppose
exploitation.
I was just. I haven't read the whole of TD&A. I don't think we need to unless you want us to. But there's no question of there being sufficiency of protection precisely because of international conventions and special attention paid by the
No.
Albanian police. It's not that kind of.
No, there are
okay.
some moves towards protection and reintegration for trafficking victims and some international NGO support, but there is also significant societal disapproval of those who have seen to be engaged in prostitution, whether willingly or unwillingly. So there's a societal bias.
No, sorry, you
against them as
misunderstood.
well.
I was wondering whether the reason why the default position is there is sufficiency of protection for victims of sex trafficking is because victims of sex trafficking get special attention because of the international interest in the subject.
There isn't that's not the case. There is some international NGO presence for shelters and reintegration and financial support, but not in terms of the police. No, and there is to some extent a police as well as societal bias against those who've been seen as prostitutes, whether or not they were willingly. So there is a slightly different balance of issues from this case. But my learned friend does rely on TD herself, including before the upper tribunal. So in my submission, it is relevant at least to consider it. And again, relying on TD before this court, the appellant says, well, there are some cases of sex trafficked women where there isn't a sufficiency of protection because of their particular circumstances. So the appellant has asked you to consider it through that lens. And should you do so, I'd ask you to bear in mind that the standard is there's a sufficiency of protection unless special features apply. The judge considered in some detail the expert report in this case and why it is that the expert thought she might not be able to obtain a sufficiency of protection. He referred extensively to the relevant CPINs. There's a number for Albania, and the government...
Just show us the passages you're referring to.
If I can ask you to turn first to paragraph 14, where those are the respondent submissions which refer to the Actors of Protection CPIN.
So the
14 of what?
Paragraph 14 of the upper tribunal determination. It's a very long paragraph and it's approximately a third of the way down.
Yeah, which is the beginning of the sentence.
It's at https://ein.org.uk Home Office, the CPIN Actors of Protection. And that deals with the adequacy of protection, the effective legal system. There's a sufficiency of protection internally, not achieved in every case. And the CPIN on blood feuds was also referred to at the bottom of paragraph 15. And when after the decision had been reserved and the judge was considering his findings, he focused in detail on the issue of sufficiency of protection and considered on the basis of all the evidence which was before him that...
Sorry, which paragraph are you now referring to?
The conclusions start at paragraph 30 and the relevant part starts at 35, the second half of that, starting the law of Albania outlaws discrimination.
That's really irrelevant, isn't it? Why does he say that?
Because it's a starting point, a degree of protection against gender-based violence consistent with limited
But as
resources.
I understand it, the threat is not gender-based violence, it's family of a debtor-based violence.
There's two parts of it, and it has been put...
I see.
There's something of a mixture of the two, because that does then go on to consider the blood feuds type later down in that.
I see. Anyway, so you're referring to this passage.
Yes, and that he considers what the expert had said, Dr. Tehiraj criticises, and talks about blood feuds and trafficking and a feud of power versus a disagreement, and then refers to the CPIN, and considers reporting to the police what happened last time she reported to the police, paragraph 36, and the option in relation to shelters in paragraph 37. So it is considered on the basis of all the evidence before him. And the submissions made in relation to sufficiency of protection are in effect a disagreement with that conclusion.
Yep.
The third part of that is internal relocation, which of course is a sort of in the second alternative, because he had already found there wasn't any risk and anyway there'd be a sufficiency of protection. But in the third alternative, the judge concluded that she would in any event be able to relocate, and he did conclude it would be within Tirana. He knew and accepted that her previous persecutory level treatment and her husband's family had partly been based in Tirana, and he was aware of that. But he also said that it was the largest city in Albania by some margin, and she would be able to live in a different part of it. He considered that in mostly paragraph 43 onwards.
Sorry, different part from what?
Of Tirana.
Yeah, but different from what?
Different from the section where her former in-laws lived.
Right.
Or where the former business was, presumably.
Yes.
There's two geographic links.
Yes. And he considers that, starting at paragraph 43, that it would be reasonable to expect the appellant to relocate. He considers in paragraph 44 exactly why the expert had come to the view that it would be unreasonable, and he considers it and he applies a correct test in 45, the correct approach, and considers the appellant would have to show it was unduly harsh by the standards of her own nationality, says you'd need to distinguish between the place she came from and the place to which she might...
Well, that's all true, but a bit of a red herring. It's not a point anyone was taking, really.
Well, it is because of Tirana. The suggestion that Tirana isn't relocation made by my learned friend this morning.
I may have
because it's
misunderstood.
all
I thought he
Tirana.
was making the point which you often get in these cases. You're going to have a life in the place of relocation is much worse than life in England, and the case law is all about whether saying that's irrelevant.
Yes.
It should be whether it's much worse in the place of relocation than it would be elsewhere in the country to which you're being returned.
Whether it would be unduly
I
harsh
see. Well,
by
okay,
Albanian standards. I think that is also considered in that paragraph, but
I
it
see.
does show that he was aware that Tirana was an area of alleged risk, because first 46 says the appellant claims to fear her husband's family, who are said to live in the Tirana area. So he was aware that it was the same city, but he goes on to say it's a large city, and you could avail herself of Tirana because it's large enough and populous enough. And if necessary, she could avail herself of hostels or other facilities for single mothers. So he has, in my submission, considered that. He's applied the right test. He's considered what the expert said. And he has considered that, in fact, it would not be unduly harsh for this appellant in light of all the evidence before him. And in my submission, the disagreement with that is a factual one and not a legal one.
That's solid, is it, as a matter of law? I've never come across a case of a judge saying you've got an internal flight alternative in the same city as you came from, where the source of the problem is. I've just not come across that.
I can't remember if I have or not, but it's not ruled out as a matter of law. And you could quite easily imagine saying that somebody who's in danger in Croydon could go and live in Wembley and not consider that that was the same place. There's nothing in law which says it's got to be a different local authority area or settlement.
It's made to sound odder than it is by putting it under the label of internal relocation. Ultimately, he's making a assessment of if she had to go to Tirana, could she be safe there?
Yes, I suppose the implication more is, well, if you're not living next door, is Tirana safe, rather than are you perhaps the implication is more that he's saying if you're not living next door to your former in-laws, is it safe, rather than if you relocate from north to south or east to west. But as a matter of law, I'd suggest it's not inadequate. doesn't have to be a certain distance away or a different local authority or anything of that description. Although I'd accept your ladyship's point that no cases come to mind where it's relocating from.
Usually that's talk about going back to a different part of the country, like you were the issue doesn't arise. I mean, I take your point. I mean, what it's really saying is there isn't a risk for her. It's actually sort of folding into the first point, isn't it?
That might be correct, yes.
The judge asked a sensible question: is would there be a safe place for the appellant to go? And I mean, the safe place we often see is, as has been said, is long distance away, other end of the country.
Yes.
But I mean, actually, a safe place could be in the next street, provided you were taking steps to be completely unrecognisable and covering your tracks. You've got to look at the individual case as to what is a safe place to go.
Yes, and I'd agree that there's nothing excluding as a matter of law a different part of the same city or province or anything of that sort. I'd accept that normally Home Office refusal letters will say something like, well, if you're in danger in Peshawar, go to Islamabad, which is a very long way away, but it doesn't have to be. All of those matters are addressed in my skeleton, which I continue to rely upon, but I would just conclude by noting that the appellant does have to succeed on all three in order to succeed on that. And in my submission, taken as a whole, these are challenges to a decision she doesn't like and doesn't agree with. Ground 6 is a completely different area of the case, in that it relates to Article 8, 276 ADE. The submission made by the Secretary of State is similar to the extent that the Secretary of State says it's a decision that the judge was open to come to on the evidence properly before him, and that he made no errors of law in considering it, although it is a separate set of the evidence to a large extent. I have emailed to your ladyship's clerk the extracts, because I thought that might be more helpful. I don't know if your ladyship's clerk's forwarded it to your ladyship yet.
Yes.
I am graced with many emails.
I apologise.
It looks like I have got it. Yeah, I have got it from you. So, I'll make sure the others get it as well.
Because the link I'd sent this morning has the whole lot, but it is.
No, I see. But this is about 276 AD.
Yes.
Well, put us out of our misery. Is there a dispute about what is the applicable provision?
I don't think so, because the wording is the same in 276 ADE and Appendix PL. By the time
What's Appendix PL?
Appendix Private Life replaced 276 ADE.
It shows how long it is since I've done one of these. When did that happen?
It happened in April 2023 or July 2023. I think it was July 2023, but it was April or July.
Well, it seems to have overlooked everybody at the time of the hearing.
It does, and you will still.
You would have
see
thought at
judges.
least the Home Office presenting officer would know what the current one. I don't want to be too rude. We know only too often. They don't seem to know. But so in fact, all this 276 ADE, all that ludicrous numbering, that's all dead, is it? And similar provisions now appear in somewhere called Appendix PL.
Yes, which is numbered in a similarly eccentric and imaginative fashion, but a different one. It's the same test, so it doesn't.
Yeah, okay. Well, let's not spend any more time on it, except that we want to get it right in our judgment. So, is what you have sent to my lady, and indeed the bit of PL rather than the bit of 276 ADE?
That was what was in force in October 2023.
Yes, I see. Well,
What I have got, I'm looking at it on my screen, it says it's 276 ADE and Appendix FM.
Yes, so it should be. It's got an attachment, my lady.
I'm in that. And
sorry.
that says
What page?
it's in an email that went to all of us.
What's the page in the scan?
I'm sorry, I
No,
beg
on
your
an
pardon.
email. On an email. So that's 5th of October 23 to 14th November 23.
Yes, so I had to edit it ruthlessly, otherwise it's 1,600 pages, but it includes the index showing it's the right one. the 5th of October.
We shouldn't be having to waste time on this. It should have been picked up in the skeletons, even if it wasn't picked up below.
Well,
Sorry, that's just me being grumpy, but this is so fundamental in these cases, and there is some burden, not talking about you personally, but on the Secretary of State side, given that you're better resourced, to make sure that we do have the right rules in front of us.
there's no dispute really, though, because it's the same
Well,
wording, and the judge has got
Well,
it right.
I dare say, but when the Court of Appeal, we don't want to write judgments which refer to the wrong rules, even if they're the same as the right rules.
Yes, I apologise.
Okay.
276 AD is deleted at
Yep.
that time, and Appendix PL, standing for private life, had come into
I see.
existing, but it's the same test.
Okay.
Very
In this thing that you've sent through, I think what I'm going to ask you to do actually is just put it on one side of A4, if you wouldn't mind. 'Cause
yes.
that
Yeah.
that's all good and fine. And
I
whatever
apologise.
dandy.
Doing it.
But I
here.
haven't got an appendix PL in here because mine's. I just haven't got that.
I beg your pardon.
I've got.
If your ladyship turns to
It's not in the index.
1226 at the bottom.
Yeah.
That's a private life route, but I was doing it in a hurry over like
Could
time.
I just, could we ask that just for us?
I'll send it.
It's in your mind.
Yeah.
I don't think it'll
Well,
take you
my,
much
my,
less
my
time to
lord,
do
my
something.
lord has found it, and speaking for myself, I'm sure none of us doubt that you're right. And now I've got over my grumpiness. I'm
Right,
grateful, but the only important thing is it says the same as 276 ADE 16. Where is it says that?
Sorry, I'm just turning to it is
PL 5.1 is that?
PL 5.1 page 1226B.
Last page.
The decision maker must be satisfied. There would be very significant obstacles to the applicant's integration.
Okay. So it's PL 5.1B.
Yes. And that was in paragraph 12 of Upper Tribunal Judge Hanbury's decision says paragraph 276 ADE 16 was referred to. This is now to be found in
Oh,
PL 5.1.
So he was right.
He
I'm
was
so sorry, and I just didn't pick that up. Well, there we are.
Which is why I didn't provide it, because he is right. So there's
Okay. Anything rude I said about anybody, I now turn on myself. Where did he say it?
paragraph 12, first sentence.
Paragraph 12, probably that means that Ms. Warren takes the credit.
Well, I'm not
See,
sure it
so-
does
so-
actually. No, I think what's happening there is the judge was saying you now. I must say, well, I did read that, but I'm afraid I just thought it was some reference to one of the bundles. I hadn't realised it was a different rule.
I'm afraid to say I think the judge is congratulating himself on knowing that it's changed from
Yes,
276
I think that's what's happened. Right. Well, let's not spend any more time on this. We all agreed what the substance of the rule is, and we now know what the correct
And
place
I
is.
accept as well that the judge refers to insurmountable obstacles on 2 or 3 occasions, which is Appendix FM EX, and applies to married couples where one of them lacks immigration status. However, in my submission, he clearly knows what the rule is and knows what the test is, to the point that he managed to correct my learned friend on a matter that didn't make a difference, but he still knew what it was, and said that although it's changed from 276 to PL, the test is still whether very significant obstacles. He's a specialist sitting in a specialist tribunal, and in my submission, the fact that he's said insurmountable obstacles a couple of times really doesn't mean that he isn't aware of what he's deciding and isn't careful about it and didn't consider the right things. And that's 47 to 49. And again, he pointed out at the time of the application it was 276 ADE and Appendix FM to private life. And in my submission, he really has considered all of the necessary and relevant features. And he's already considered them on the facts quite a lot already in relation to undue harshness. And he even
Where does he with undue harshness?
well, the undue harshness for whether internal relocation would
Oh,
be
I see.
unduly harsh. Quite a lot of the same material is relevant, and he has already considered she's multilingual, she's well educated, she's moved to Italy, she's lived there, she's smuggled herself to the UK.
He says,
she's
by the
lived
way,
here.
that she's got a law degree. Ms. Warren said he's wrong about that she didn't finish the course.
I'm
Yeah,
not sure,
okay, right.
but
But the evidence is what it is. We can find it if necessary.
if she's even done a part of a law course in Italy,
Yeah.
that's still particularly in Albania, a high level of education, and she'd lived and worked in Italy. He says, and it's a fair comment, that she's in generally good health.
Can I just say about work? Do we have it during the time she lived in Italy, apart from the short gap when she was on her way here? Is there any evidence about what work she did there?
I believe there's some reference to her having worked possibly as a waitress or
Precisely.
as a-
Well,
but
again-
she was studying as
Yes,
that's when she was
obviously-
at university. So
And she, presumably by definition, she won't have worked here, and she's certainly not legally.
she won't have been working here
No, quite.
legally, no. And she was pregnant with her youngest child fairly soon after arrival. So even if she then got permission to work after a delay, she'd have had a
Okay,
newborn
fair
baby.
enough. Yeah, that's enough.
I would ask, and I appreciate I need to
No, you're
do
all right
so.
for time at the moment.
Relatively briefly, there are references in the skeleton argument in the grounds of appeal to saying her mental health difficulties and her child's cancer treatment. And I'm going to ask quickly that you do look at a couple of those documents,
Yes.
because the evidence is relatively thin about there being any risk to the child in the future and about the appellant's mental health being serious. It is, of course, clear, and it must have been an extraordinarily traumatic and difficult time to have a baby diagnosed with cancer and have chemotherapy. And when it's pointed out that this caused her immense anxiety, inevitably it did so. But it is worth pointing out nonetheless that this was a benign tumour that was treated because of the risk it would press on other things and cause neurological difficulties. That the consultant was being extremely positive about the prospects of treatment right from the beginning. And there is nothing to indicate any significant medical treatment is planned at the moment or particularly likely in the future. There are the two letters from Dr. Howell, pages supplementary bundle 332. And again, I'm not going to ask you, Your Lordship, to read all of those.
Sorry,
now.
it can't be 332.
Of the supplementary,
A supplementary bundle. I thought you said 332.
I did. At the top right, it says Underhill Children's NHS Trust.
So I've only got 300. Am I going round? I've only got 320
I think
pages.
220 in our.
I think there's one on page 20, Dr. Lisa Howell. Is that right?
That's.
Yes.
But there are several from her.
Later one, yes, the later one is 20.
The one I think I've flagged up in the past is, as my lord kindly said, 220. The date dictated 11th of January. Typed up the next day. Is that the one?
Yes, I think I've got the index before my. I'm afraid I think I printed myself the index before my learned friend and I got ruthless with the material in it. So it should be dated the 13th of September 2021.
13th September 2021. Oh.
And it's an NH. It's referred to as
Yes, that's
letter
at page 224.
from Dr. Howell, consultant. I'm afraid I think I did print the old index. So this is the letter which was written for immigration purposes.
Yes.
Third paragraph, I expect Noah's prognosis to be excellent. And the letter to the GP, which is of the same date on the following page, again says that this was diagnosed and
Sorry,
treated.
I'm sure you're right. No, GP, as I see on page 226. That's
Yes.
same date. Yeah.
And that's quite a lot longer letter. And on the second page, the anti-penultimate paragraph starts, I discuss the implications. And it says, we've elected to treat this tumour as detailed. I expect Noah to respond to the treatment and live a normal life subsequently. So it needs to be carefully considered, and an eye needs to be kept on him. But the case can't be approached on the basis that this is a child with urgent, significant and ongoing and complicated medical needs, because there is no evidence that that is the case. And the most recent update, which is the letter from, again, it's Dr. Howell on page 20 from May 2023, that's the most recent one. And that says he had a 6-month checkup, see him again in 6 months' time. So, of course, no one would say that this is something that shouldn't have caused the appellant immensely anxiety and upset at the time, but you're not dealing here with a small child with ongoing or complex medical needs, necessarily. And when it comes to the mental health, again, it was obvious that this diagnosis of her baby was extremely distressing. But the last evidence, again, you have is October 2023, and it talks about her being anxious, about the stresses of being a single mother on very limited income, on asylum support. It doesn't support the contention that she would be exceptionally vulnerable or at risk compared with other women in the same position on return. So the evidence was before the judge, and it can't be said that he didn't take it into account, or that there's something in either the medical or the mental health evidence that he has completely overlooked. And
This page 15.
of the supplementary bundle,
Yes.
Yes. There's two. There's 15 and the subsequent one. Yes, that's correct, my lord.
Yes, I mean, to be fair, it says depression and anxiety. Doesn't suggest she's on medication. She's on
She
tour.
is.
Oh, is she?
It does at one point.
Yes.
I missed that. What medication is she on? Antidepressants.
Serotonin, I think.
It's sertraline and propanadol, which are both fairly standard medicines at the top of page 19.
Thank you. Top of page 9.
19.
Yes, that's right. Well, the sertraline, I certainly know about. Yeah. Okay.
So when the judge has said in his determination, healthcare in Albania should be sufficiently robust to treat him, now he's had his primary treatment on the NHS, that's really a legitimate reflection of what the evidence says. And when says in relatively good health, and Albania does have a healthcare system of sorts to care for Noah if necessary. Really, that's a legitimate reflection of the evidence before him. He was entitled to come to those conclusions. It's not just that he's just about got it right, it's a fair reflection of the evidence. And the appellant's disagreement with it does not amount to an error of law. I said I'd leave ground one until the end.
Yes,
in case
just give me 1 second. I just want to look again at. The question he asked himself, I'm looking at the judgment at just a heading above 50, would the appellant's removal here be necessary and proportionate? Well, I mean, those are obviously well-known phrases, but is that some test he's borrowed from somewhere, or is that just his own shorthand?
It sounds like he's borrowed it from Huang, thought. But,
So I think that's a point, in fact, you made in your skeleton, isn't it? I've forgotten, yes.
but those are the tests. It would, I suppose, he might have said lawful and proportionate. But it is also subsequent to the material he's also recorded under 7 above, where he says there's a two-stage exercise. First, does it meet a section of the immigration rules? And secondly, should it exceptionally be granted outside the rules? And he's referred then to, at the time of this application, paragraph 276 ADE 16 applied. And then says you go outside the rules only if it doesn't meet the rules to start with.
Can you help on when 51 he says subject to caveats above, house herself?
My understanding of that is, although I'm not entirely certain, that why she should not find employment and subject to the caveats above house herself, because there's a reference to she could seek housing in shelters or with the local authority.
That may well be right.
Paragraph 37.
He doesn't refer, you say he's all legitimate. It's pretty broad brush stuff. And there was a good deal of evidence, or some evidence from one person, namely Dr. Teheraj, about difficulties of finding affordable housing, especially for single people in Tirana. Has he said enough about that?
I'd suggest he has, and that you could take any judge's judgment and go through it and find that he hasn't referred all that much to one particular part of the evidence. And really you could do that with any judge. And that was one part of his decision, but that nevertheless, he has gone through it in sufficient detail. He's referred to the experts several times, even if not every page. And when she says social housing is difficult to come by and housing is quite expensive, you could certainly say that about living in the UK. It's extremely difficult to access social housing, and private housing is very expensive, and there's not enough of it. That doesn't mean necessarily that life in the UK is always unduly harsh either. So he is entitled to say, yes, there might be some difficulties. She might have a slightly lower standard of living in Albania than she would here, and she'd certainly like to stay here, but nevertheless it will be possible for her to house and herself and find employment. And if she cannot do so or is concerned for her safety, there are the NGOs and the shelters and so forth on top. So I cannot be entirely sure, my lord, but
Okay, no, well, that's the best answer you can give.
Subject to the caveats, that's what I would suggest that he meant. So those were my submissions in relation to Article 8. Ground 1 I have referred to in a little more detail in the skeleton.
Yes.
In short, firstly, it doesn't matter unless she wins on all of 2 or 5 anyway. Secondly, it probably doesn't really matter anyway, because the difference in a humanitarian protection visa and a refugee visa are very small. They're not 0, but they're very marginal.
Yes, I over lunch I read a bit more of 4.9. In that case, Lord Bingham says there are significant differences, but maybe they've become less significant since 2006 or whatever that was.
They've become very much less significant.
Okay.
I think.
For example, if you're entitled to humanitarian protection, no, forget it.
You're used to only getting a year's visa at a time on humanitarian protection, and now it's the same. It's 5 years, and you used to get ILR straight away as a refugee.
Yeah.
I don't know exactly when that changed, but you get 5 years on both now.
Yes, I see. Okay, so your main point is doesn't matter much.
No, or there are. It matters. It's a bit harder to be deported if you have a refugee visa than a humanitarian visa, and there's a bit of a difference about home university fees. But those were the only 2 I could think of
But it
those.
really depends upon at what point Miss Warren, as it were, ceases to succeed. I mean, let's suppose that her first, her second, her third arguments succeed. Then one might get to the point where, having succeeded on everything else, she was entitled to ask us to say that she succeeded on ground one as well. Are you following me?
Yes.
But that if it were different and she fell at an early offence, which was also fatal to ground one, then this may not be the case in which to get into the conceptual issues relating to, is it a family or is it a family who are being chased for debts?
It is quite a complicated issue, and it does appear that it's probably more important to other people, other applicants in the future than it is to this appellant, which one she's declared as. But as
But
your lordship says,
the fact is, we all, we can't discount the possibility we may have to deal with it. So we have to deal with it.
Yes.
Yeah.
So, but what I would say is that if she fails on any of 2 to 4, then it doesn't
You'd
matter.
encourage us not to get into it.
Yes, because it doesn't matter if she's not a member of a social group or not a member
No,
of
of
not a
course.
social group. But if your lordships do conclude on 2 to 5 in the appellant's favour, then I'd agree that you do have to
Yes, of course.
consider it. I'm a little bit confused between the difference between a social group being a member of a particular family and that she's a member of a social group because she's a member of a family, because it does appear to me that almost everybody is almost always a member of a family.
Right.
Including by absence as well as presence or adopt. I can't see who isn't.
I didn't understand Ms. Warren to be demurring from it having to be a particular family.
But it did seem to me it was a family with particular properties that would
Yes.
need to be considered.
Well, I agree. I think that's where the distinction was.
And
It has to be that family.
Yes, the family on which she is a member.
The family Jackson, family Underhill, whatever it is, because of something that affects those families.
Yes.
yes, and perhaps I'm getting unduly hung up on the semantic difference between the two, but it doesn't appear to be clear from Fauna that the persecutory element and the immutable characteristic as the definitional element still have to be separate things. The reason for the persecution doesn't in itself create the social group. There has to be something else that's a visible social marker, an important immutable characteristic, which isn't just the persecution itself. Otherwise, and this has been said fairly often, almost the fact that some members of a group are persecuted by itself means they're persecuted for a convention reason. It becomes circular. There has to be something outside the fact of persecution that makes the group identifiable and
Well, we don't need to talk in these very theoretical terms. Fauna does face up to it. He talks about the family. And I thought the position adopted by Mr. Justice Laws and approved by the House of Lords is that if you are being persecuted because you are a member of a family, obviously there will be something about the family which causes you to be persecuted, what your husband is thought to have done, or but not always a convention reason. But the actual particular social group is simply the family to which you belong. And the limiting factor is the causation. But it's not very common that you will be persecuted for being a member of a family.
No, but what the former does also say is there has to be a link between the persecution and non-protection for persecutory reasons linked to the social group. So at the bottom of page 118 of the authorities bundle, it says that fear of non-state persecution is not sufficient to make a person a refugee unless the state discriminates in affording protection against harm on the basis of the relevant characteristic of the claim.
So sorry, I'm being slow. I'm in the authority.
It's
Oh, I'm not in.
118, right at the bottom.
Give me a moment, sorry.
Within the head note, yeah?
Yes.
As my lady says, that's the head note.
Yes.
No, it's not even the head note, that's submissions.
I thought it was the head note. I beg your pardon.
Vague submissions.
I beg your pardon. I got confused.
Distinguished team. But I mean, so that's not going to help.
No, there is also. I beg your pardon. There's the.
Proves my point about the advantage of having a proper law report.
So yes, it was. I was also intending to refer to something in Lord Bingham's speech. I think it's about paragraphs 12 or 30. I mean, it's paragraph 11. There's the 4 convention grounds, and then there's the reference to Shah and
I've got paragraph 11.
Islam.
What's the passage you're getting help from?
The paragraph. Sorry, let me just. I think it's 9. It's 17 and 18. Has a well-founded fear casually linked with the convention.
Causally linked, I think that must be.
Yes.
Yeah.
And it's the more sophisticated and contentious approach.
So where are you saying sophisticated and contentious approach?
That's what Lord Bingham says in
At the bottom of the
end
paragraph, right? Okay.
17.
Let me just read the whole paragraph then. Well, all that's fine, but that doesn't really meet the point. It doesn't really address the point.
No, but when I was saying a sophisticated and nuanced approach, I was saying that was what Lord Bingham said was necessary. I wasn't suggesting I was myself explaining such an approach. But what it does say, that if a person is punished because he is, for example, the stepson of somebody who won't cooperate with the drugs cartels, it might be that somebody would be entitled to be treated as being a member of a particular social group because it was a family member. And at paragraph 24, the adjudicator had found that in this particular case, somebody was a member of a social group because of the drug dealing family link, and that the adjudicator had been entitled to do so. So did the adjudicator misdirect himself or reach a tenable conclusion?
So where are you reading from?
This is bottom of paragraph 24. That a family may be a particular social group. Was the adjudicator entitled to find in this case that the appellant was? And Lord Bingham agreed that the adjudicator didn't misdirect himself and had been so entitled. So it's not quite saying a family member is a member of a particular social group. What he's saying is, in that particular case, the adjudicator, having found all of the evidence and found the facts and considered all the evidence, concluded that this appellant was in fact a member of a particular social group, family of somebody not wanting to be involved in drug dealing, and the adjudicator was entitled to find that and hadn't misdirected himself. That's not quite the same as what the appellant is saying in this case, where the judge has found that this appellant was not a member of a particular social group, and she's inviting that be overturned by this court. what Lord Bingham said is it was possible to find, not a breach of law, and the adjudicator was allowed to have found it.
Taking that point on board, though, given the primary findings of fact in the FTT in dealing with the disgruntled customers persecution, it's inevitable, isn't it, that she is being subjected to that subjectory treatment because she is a member of her husband's family, effectively, because she's married to her husband.
It's very probable that the past treatment should be seen as having been for a convention reason. It's entirely possible it should be, but that's not the relevant question as to whether she has a well-founded fear of persecution for a convention reason on return.
Well, right, there's a whole separate question which you addressed us about whether actually there is such a, but suppose there is a well-founded risk of persecution, a well-founded fear of persecution on return by disgruntled customers because she's married to her husband who has cheated them. Wouldn't that fit in? Wouldn't that?
She's not anymore a family member. She hasn't seen him for sort of 6.5 years.
Well,
To
she's
what
still
end?
married to him, and the reason why they would be persecuting her, if they would, was they thought that persecuting her would be a way to get to him.
That
Perhaps.
might well be right for the first category if, of course, contrary to the other submissions I make, you were to conclude
Of
that there was
course,
a
no, no.
well-founded fear and sufficiency of protection and internal relocation, that might well be the case. But that wouldn't apply to her second category of claimed fear from her separated husband and his family, because that would be be completely different category.
Well, I wonder about that. That would be because she has had a child by someone else while still married to their relative.
Yes, it's been a slightly shifting target of
Well, I understand that, but
of social group, women fearing domestic violence or women having adulterous children out of adulterous relationships and so on. That's perhaps not a matter of absolute crucial certainty if it is slightly shifting, but that's a completely separate social group and set of circumstances.
okay.
So there'd be two completely different social groups to be considered.
Is it sort of rather reminiscent of arguments about status in discrimination cases, where you can have a lot of argument about status, but it very seldom turns out to be the real argument.
I think your lordship probably has immensely more experience of that than I do, but comparators have always caused me to hide behind the sofa until someone else has sorted them out. So
where are we on the protected groups? You say fauna doesn't help at all on the first group, which is persecution as a member of the family who owe debts that are being chased.
yes.
And you say the same thing, it's obviously a different group, but if the point is fear of persecution by her own ex or in-law family for whatever's happened since, you say same analysis, but you come to the same conclusion?
Similar, but it's even stronger in the case of that, because there's
Well, stronger for you or stronger for them?
Stronger for the Secretary of State, because there is country guidance which says that a fear of domestic violence isn't a member of a particular social group.
Or
DM.
T.
DM says women in fear of domestic violence aren't a particular social group. AD
That's
and
an upper
TD,
tribunal decision.
Yes, upper tribunal. And AD and TD says that women who've been forced into prostitution and sex trafficking are. So there's country guidance cases from the upper tribunal, and the judge had to follow the country guidance unless there was sufficiently clear evidence. It's that curious category of factual precedent that you mostly get in the upper tribunal. So the secretaries.
As to DN, but it's in your skeleton, isn't it?
It is in my skeleton, and it's accepted in my learned friend's skeleton that is the country guidance case. She makes
She says it's 20. She says it's 20 years old.
yes, she makes criticisms of it, but I think she accepted is the current country guidance on domestic violence. She says that this appellant is in a slightly different group, not domestic violence, but illegitimate child from an adulterous relationship. So, and I in the skeleton as well, paragraph 19, I've relied on ROBA, which says you've got to follow a country guidance case in general, unless there's a really good reason to and evidence to depart from it.
It's not really a country guidance point, though. It's a point of law, isn't it?
Country guidance cases do have a slightly hybrid quality. They are sort of legal
No, but in a country
precedents of
guidance
fact.
case, you could simply have a simple misdirection of law. Country guidance cases, what makes them special is they make generalised findings about levels of risk for particular groups in particular countries.
Yes.
A finding as a matter of law that a victim of domestic violence doesn't come under the concept of a particular social group isn't really, it doesn't make any difference if it's country guidance or not, does it?
Possibly not, but it would still be it was still a published upper tribunal decision at the very least. It's 20 years old doesn't
A point
really
of that kind, I wouldn't have thought it made any difference, no.
No, and the appellant also says, well, domestic violence hasn't been reduced significantly or abolished in Albania, which in my submission is again not quite the point. It's not said it's got infinitely worse, it's just not gone away.
Right.
So neither of those really apply. So fauna applies perhaps more significantly to the first family.
I thought we'd almost got you to the position with fauna where you hadn't made any formal concessions, but you saw how the case could be put.
I could see how it could be put,
Yes.
but that's not what I wouldn't extend that to the women, illegitimate children, domestic violence social group. It's not quite the same. In fact, it's an entirely different group. So unless I can assist further, and
Not as far as I'm concerned.
thank you, my lord.
Warren, do you want to say anything by way of reply?
Yes, just a few discrete points to come back to. I don't want to add fuel to the fire of the question of the immigration rules, but I do feel I need to point one matter out. I apologise. Sorry, my laptop decided to shut me out. The reason why 276 ADE was relied upon is because on the 15th of March 2022, the Home Office published the Statement of Changes, which was HC 118, which were
8118.
HC 118.
HC 118, yes.
And this was the insertion of the new appendix private life. And it said, this will take effect on 20th of June 2022 and will apply to all applications made on or after that date, replacing paragraphs 276 ADE to 276.
I see. So,
And then it says, applications made before the 20th of June 2022 will be considered under the rules in force on 19th of June 2022, even if they had decided after that date. So the application...
and annoyingly, they've done that over the years. They've done that different ways. Sometimes they have applied it to current ones, and sometimes they've said only to new applications from this date. And this is a new applications from this date one.
Yes, and it's applications, they use different... It can be difficult to know when the rules come into force. I took it, I could be corrected, but I took it, the application was, even though it's remaking of decision, because the focus was on the application.
Well, if you're right, if that is exactly what it says and it talks about the application, then I think it means what it says and
Yes.
doesn't mean the decision.
And the application was made on, I think, the 2nd of February 2019. So
Yes. No, but we can see Well, look, I don't think we want to spend any more time on this in court. I think it would be helpful if it could. It really doesn't matter, except for the point I made before, that we want to get it right.
Yes.
Agreed.
And can the two of you just put your heads together? Ms. Jones, if that is right, and if there aren't hidden subtleties, it suggests that Ms. Warren and or the judge may have been right all along.
For reasons I'm not going to be boring with, I'm not convinced she is, but
No,
that's why
I know
my
it's a very
starting
tricky
point was
area.
it's the same test.
Now, can the two of you produce, if possible, a joint note?
Yes.
If you can't produce a joint note, can you produce short several notes? If the worst comes to the worst, we may say it's one or the other and it's too tricky and not worth being into in this case, but at least we'll know where we are.
Yes.
Thank you.
Yes, briefly about the suggestion that the appellant's mental ill health was related to Noah's ill health, or could be related to that. The medical evidence was that it was also related to her prior experiences.
Complex PTSD.
Yes, in Albania, including the rape. And it's not put on Article 3 basis, this appeal. It's always been tied to the factors of care and consideration of her children and her ability to do that, which is why VNM and the judicial review case is referred to, because it's a particular aspect of considering mental ill health.
The way one would have to look at it would be that her mental ill health was unfortunately so bad that it would severely imperil her ability to keep the family together. Yeah.
Or provide adequately for the family.
Well, I mean, keep the family together in all senses.
Yes.
And the judge had to take a view as to whether it was one of those cases, or whether it was a case when it was just going to be very difficult.
And to that end, I just wanted to bring the court's attention to page 315 of the supplementary bundle, which was a letter from the 4th of December 2020, so predated, obviously, when Noah was not born at this stage, and obviously he hadn't been diagnosed. It says, throughout her consultation, this lady was in an extremely distressed state, feels no hope for the future of her life, inconsolable throughout the prolonged consultation. She's struggling with her mental health and also having to look after 3 children as a single mum. So it ties it in particular to those. It isn't something that is isolated to whether Noah's cancer was treated successfully, or if there'll be a relapse of that. The next point I wanted to quickly come back to was the fact that it was said that there wasn't further evidence put in about the risk from Noah if she was to return to Albania.
Risk from Noah?
To Noah.
Sorry, no, I've put that wrong. There wasn't further evidence put in about the risk that would arise from Noah having been born to her if she was to be returned to Albania. And that would be the risk of the family discovering that she'd had an affair with outside her marriage, and that was the cause of having a further baby. Of course, that's a risk. I've taken the court already to the evidence in relation to that. There was no evidence to be put in at the later stage. That risk becomes triggered when his family in Albania come to know about Noah. So the fact that there are a few findings on it in the First Tier Tribunal is not unsurprising, but also the judge says that paragraph 30, page 68, this is Judge Hanbury, I will not hold back from looking at the credibility of any updating evidence placed before the tribunal, which needs to be carefully considered. So that's his approach to the question of credibility. It was a live issue in the error of law hearing and the remaking decision. He could have raised arguments about that, and he didn't do so. He reserved that to himself. Essentially, there was nothing in that point to be made that there was any deficit on behalf of the appellant. And the final point, I thought I should just clarify in light of my friend's submissions, that the fauna point is confined to the risk from those who would pose a threat to the appellant because of the activities of her husband and the fact that
Precisely,
he's
thank you.
renegated of
That's
their debt.
helpful.
I don't know if you want me to address you more on the fauna point, but I hope that clarifies that.
Thank you very much indeed. Thank you both very much. We will be reserving our decision. Judgments will be circulated in draft in due course for the limited purposes identified in the Counsel General for Wales case, and which include the agreement of a draft order, or if you can't agree, any rival submissions on what the order should say. You are aware that they should only be circulated so far as necessary for those purposes,
Yes,
and it would be serious if they were circulated more widely. And you're kindly going to try and agree a note on which were the governing rules and why, just so that we can be accurate in our judgments.
If I were to forward it to, or we were separately to forward it to your ladyship's clerk, to whom I sent the relevant sections of the immigration rules, that
Will do for all of us.
Yeah,
Yep. Thank you
Make sure
very
that's
much
fielded
indeed.
on. Yeah.
Good.
Thank you.
Thank you.